Morning, everyone. How's everyone doing?
Morning, Amy.
Morning, Grace.
Morning, Amy.
Morning, Dennis.
Morning,
How's everyone
morning.
doing today? Morning, Tim. How's everyone doing today?
Doing good. How about yourself?
Pretty good, pretty good.
How was the
So
wedding?
it was great. It was
Good.
great. We went out to Colorado to visit the mountains for our honeymoon, and that's when everything turned sideways. But it was great while we were out there. Our flight got bumped, so that's why I had to postpone last week's meeting because I was on a flight at that time. So I am back now, and everything's good. Now it's the fun times of switching over my name and all that fun stuff.
So what's your last name now?
Helmer. I just
Helmer.
noticed that I needed to update that on the Zoom when I logged in here. So it's all these last minute of, okay, do I contact the Commerce? Do I get my driver's license first and all that fun stuff? So I will probably be putting something together on name changes as well because I know I'm not the only one.
Fun.
Any upcoming listings or buyer needs that we want to talk about?
I have a need. I'm closing. This is my first one with NRG. So when I go to the closer, do I pick up the check and give it to you guys, or do I have them mail it? How do
Yeah,
I
who are
have
you using for closing?
land title in Hudson, Wisconsin?
Okay, so I don't think we have an agreement. We have an agreement with a couple people where agents can get paid on closing, but I don't think that would be one of them. If you're attending closing, then you can pick up the paperwork and drop it off at the Edina office. Otherwise, most of the title companies just mail it on over to the Edina office, and then Francis will send you an email saying, "Hey, we received mail for you. It looks like a commission check. Here's your commission," and then it'd be paid out however you wanted to be paid.
Okay. Okay. Yeah, I'd rather have them mail it.
Yeah, save you a little bit of a trip.
Yeah. Okay. Thank you.
Yeah.
I have another question.
Yeah.
Um, so when I listed my seller's property, um, I noticed that we get an automatic like landing page, and so I just did a test run, and I would be receiving messages from you.
Oh
So,
yeah, on Chime. So yeah,
so
that'd
how
be a
do
little
I?
bit more into Chime. Did you not get that figured out?
Yeah, I couldn't get it figured out so that when people do ask for questions, that it would go to me instead of you. So I didn't know how to do that. Change it
Yeah, we
over.
probably have to work together. I will notate that. Jeremy or Francis might need to set it up differently. So let me notate that here and we can work on that.
Okay, thank you.
Yeah.
And so I do have to leave early today, so I'm sorry I can't stay for the whole meeting. But
Oh no, that's totally fine.
okay, thank you.
So they can just send the checks to 5200 Wilson Road, Suite 150 in Edina?
Yep, correct.
Okay, perfect.
And that's where all earnest money, if you needed to do, I know there has been some people that have said that trust funds isn't working. We do have trust funds. It should be working. I'm not sure why some people have issues and some people don't. I mean, I've even had it personally where it was on a certain transaction where it worked well, like the week before, but then on this other transaction, it wasn't working for some reason. So I'm not sure if that's something with the other brokerages because that's always been on a sales side for me. So, but we do have trust funds set up. That's probably the preferred method. Otherwise, if you are needing to send any trust funds to the brokerage, you would be sending it to the Edina office as well.
Francis told me the reason why it didn't work for me was because um, I'm with Western Wisconsin Realtors Association, and that you guys don't have an agreement with them. That
Okay.
was the reason why.
Yeah, it must have been because it was one of my southern listings that was on. They must have been trying to look through the the RS, the Southern Minnesota Realtors Association. I can never remember the initials, but yeah, I'll look a little further into that and see if that's the issue with mine that I had. But yeah, as long as they're SPAR, they should be able to go through.
Okay. So I'm not with Spar, so then from now on I shouldn't be using that. Um,
Well,
yeah.
if listing is listed with SPAR, it should be able to be done, but I'll look into that one as well.
Okay.
Any other upcoming listings or buyer needs?
I do have I have an offer coming in, and I did get an offer on my New Hope listing, and I will be looking for a 1 to 2 bedroom condo, townhouse, north suburbs, Plymouth preferably, but around that area down to St. Louis Park, anywhere along there. So if anyone knows something or has seen something that they're aware of, that'd be great. Yeah, because I did get a home partner's offer I had posted in Facebook that was really low. And now they're coming back. He's really been coming back again and again. So we'll see what happens. But I did get another notification that this guy's writing up this morning for a different offer. So hopefully that is much better.
Nice.
And it's cash. So I feel I'm worried about it being another low ball, cash, low ball, cash, low ball thing. But my other question was from a few weeks ago, any warranty companies besides HWA or Choice for just a warranty an AC, if anybody's had any experience that, and I thought, I was hoping maybe it was Vicky or I don't know who had said before there's certain companies maybe besides Excel, because Excel doesn't cover replacement. It's I don't know. It didn't look like a very good warranty when I actually read the Excel one. Any advice?
Yeah, I haven't heard of any. I'm not familiar with Excels. I think there's like a upgraded Centerpoint one, but
Isn't
yeah,
that the same as Excel, or you have to have Centerpoint Energy for that?
I am not sure. There's like the Centerpoint Energy Plus. I don't know if you have to be a member of Centerpoint, but me,
I can look it up. I'll look it up when we're done.
yeah. Yeah, it's like Centerpoint Energy Plus, and it's like program.
Okay.
Hi, I'm jumping on here to just fill you in on my latest co-list down in Albert Lee that is just completely falling apart. So they came in and gave us a contract for deed offer with 150 cash down, and last minute decided to mortgage 150,000, which then would have left my buyer. So it was a $200,000 deal. We went down to 200. It was $150,000, cash was supposed to be brought to the table, and they decided to remortgage or get a mortgage for that, which is a big no-no. Because the lawyer that had to get involved then said this seller, then they wanted to hold 50,000 in contract. So had they defaulted, then my seller would have been liable for this extra 150,000 mortgage that was taken out on this contract. Anywho, I've got it with Sandra. Sandra's in the hospital. I'll deal with it today, but just a really big switch-a-roo right at the last minute. Really scammy. And then the agent had the balls to come back and say, well, will you just take 150 for it? What a mess. Big mess. So
He wanted to take $150,000 on a $250,000 home.
pretty much, yeah, because we had gone down from 240 for them and said, fine, if you bring 150 cash to the table, sure. But then even the title company kind of tried to push us and say, well, just close it. Oh, so then the lawyer that got involved then said, no, that seller then is going to be liable for that mortgage taken out on his property. Does this all make sense? Because I haven't dealt with it yet, but figure I'd tell you guys how fun it's been. And I'm dealing with Francis. Should I go to anybody else? I'm a little new to NRG here. I just sent Francis something this morning because I'm going to kind of take over a little bit for Sandra and try to get it back on market, but we are going to retain the earnest money.
Yeah.
That's a complete change of contract, and all of a sudden you'd be
Yeah.
second to the bank. That's
Yeah.
ridiculous.
Yeah, and then do I need a cancellation? Because
But
I
you-
don't know if those buyers are going to sign a cancellation. Know what I'm saying? To get that
Well,
earnest
you're
money.
gonna
So,
have to.
so the
I think
problem
you
is
talk
if
to an
you have the
attorney.
earnest money, you can't put it back on market until there's a cancellation of purchase agreement.
Yeah, okay, so I got to get that canceled today. We're going to reduce price. It's in our
I mean, you have to get it
when
from
it's right by
you have
lake.
to get it from the buy side, and if you're holding the earnest money, you might have to actually go through all that litigation to keep the earnest money in order for them to sign the cancellation of purchase agreement.
Do I get
So
title company involved and say, get this signed?
I'm not a lawyer. I can't advise on that. Sorry.
I would
Yeah.
ask
Good
that
answer,
lawyer
good
involved.
answer.
Yeah,
I
it would
know
have
a real
nothing to do with the
estate
title
attorney.
company. You're gonna have to get a lawyer if they don't want to sign it.
We've got one. But that lawyer's just going to have to, I mean, it's $2,000 earnest money, big deal, right? But so I
Yeah,
got to cancel it. Get it signed.
The bottom line is you can't do anything with that listing until everyone signs on to cancel. I
Okay,
mean, you got to get it canceled and then go from there. I mean,
yeah.
that just
And
sounds like a
offer
mess.
1,000 back of earnest money to
I think
cancel.
it's $2,000. I
See
think
if
it's
they do
$2,000.
that, because you're gonna spend more on lawyer fees than
Yep.
2,000.
We already
Yeah,
have.
Marjorie's
We
right.
needed
They're
a
never
lawyer
gonna
involved.
agree to giving up their earnest money to sign the cancels. So Marjorie, that had a great idea. Try to split it. Try to get them to cancel with a split for 1,000. That's a great
Okay.
idea, Marjorie.
Okay. All right. I'll
Or
push it for-
are they maxed out at that 150 on the mortgage? Can they do the whole thing in a mortgage if they want to
No,
switch?
that's
mortgage?
what we said, well, if you're going to mortgage, then you bring the full 200 to
Yeah.
the table and we'll close, we'll sign. No, we want it for 150 now.
No.
Well,
Yeah, no, we already gave it to you for 200. Anyways, it's a big mess. Can I say the agent I'm working with or no? The agent on the other side, anybody?
Yeah,
Is
say
that-
the agent.
Let me see. I'm going to go 20 deep in my messages here.
What's the
I'm not a city's agent, I'm a Duluth agent. So I'm just helping Sandra.
what's the
William
brokerage?
Yeah.
WMD Realty. William Danielson, WMD Realty.
Oh, he's his own brokerage.
Yeah.
Ugh.
Oh,
where
has
are they
been
out
the
of? Are
biggest
they out
crack.
of Albuquerque?
throw that one by
Are they out of
Randy. He'd
Albuquerque?
love to hear about that, I'm sure.
Yeah. So, okay. Well, I appreciate everybody's feedback because I just started dealing, I thought maybe it would come together, and now my co-list agent's in the hospital.
Oh,
So,
no.
Sounds
what
like
an
a
interesting
nightmare.
24 hours.
Sounds like it.
Yeah, we'll get it worked out.
I would even shoot Randy a text, say, hey, if you got a minute,
Well-
I have
Yeah, I've never
crazy
talked to
one
him.
I'm going over.
Do you want to
Yeah,
tell me quick,
yeah.
or should we do that on the side?
Randy's right here.
Oh, hi.
Hey,
Did you hear my problem?
I gotta get yeah, if everybody
guess-
wants to hear it again, otherwise you can call me when we're done.
Sure. Let's do that. Because
Are you sure?
I don't mind
whatever you want
hearing
to do, dear.
Yeah, I don't mind.
I
hearing
don't
it.
mind hearing what to do. I
Yeah,
mean,
Yeah,
difficult
let's
things come up
say
all
it
the
again.
time.
This is interesting.
okay. You want me to go again?
It'll
Yeah,
make
I have
other
to go
people
around.
learn.
It's me and Sandra. So I gave Sandra a listing
Okay.
down in Albert Lee. It's real close to a lake. It's gorgeous. Well taken care of. 240 was list. We were on market long enough that we agreed to a 200K offer. 150 cash being upfront for a contract for deed. So they were going to bring 150 cash to the table. We were going to take the extra 50 grand for a year contract, right? Big deal.
Okay.
And it is a little complicated case because it is a power of attorney with one signer, with one that has power of attorney for an estate. So we get to the closing date and, noon on closing date, the title company sends and says, no, they're going to mortgage 150. This has been recorded. So I'm not real happy with the title company either, because then they tried to convince Sandra that was okay to take a
Yeah, no,
mortgage.
because then it's illegal to bring the cash. Or wait, they had 150 cash, right?
That's what they said they had.
Oh,
So then
I
we
see.
said, sure, well, we'll get a $200,000 mortgage. We'll close it on Monday. We're supposed to close Friday. Then the lawyer got involved and said, Mike will not sign. You will not sign this, because then you're going to be liable for that mortgage that's being taken out against your property.
Jesus.
And all along, the title company kind of tried to convince Sandra this was a good idea. So,
Who's
so I'll send
Sandra?
the cancellation over to this Danielson, who doesn't answer his phone for me. He likes to talk to Sandra. I don't know if Sandra's a little newer. I'm new to
Sandra
you.
Reese?
Yeah.
Okay, well, she sold a lot of homes.
Yeah.
Is she
What
not
are
on
the
here?
mortgage
She's in
financing?
the hospital. Something's going on.
Oh. Chrome. I don't have I got a new desk set up here. I got these monitors going and I don't have a new stand for this camera. I don't know what to tell you guys. I got let's see. I got a huge monitor system so I can read the arbitration stuff if we get into it. And I just can't, something, it's not with ceiling or something. I don't know. But Sandra Reese sells a lot. I don't know. We were gonna come into another way, but I don't know. She's competent. If that's the person you sent it to, it's Sandra with our brokerage, right?
Yeah. I'm dealing with it now because, it's my contact and
Yeah.
it's getting complicated, and I've just been dealing with the lawyer for. That was kind of our agreement. I'll deal with the lawyer and the buyer if he wants, or the seller if you want me to. I gave her the seller.
I see.
Anyways, now it's a mess. I'll send over a cancellation, but it sounds like we can't get it back on market until cancellation's complete.
Yeah. I can look at it closer. I kind of heard what the stuff up, so is everybody ready to look at that arbitration stuff?
Yeah, we were just finishing up on these few questions and buyers and seller needs. So I can pop that up if no one else has
Awesome.
anything.
My question for what we were just kind of talking about is, so if they sign the cancellation and they give the earnest money back, doesn't her seller still have the ability to possibly talk to a lawyer about suing them for locking it up like that and not being able to pursue the earnest money and stuff?
Yeah, probably. Yeah, I gotta look at that closer. I mean, I kind of I don't understand. The buyer switched their finance type, and all of a sudden came in. and it was recorded. I don't even understand how all that could just magically happen. Did I miss something that you guys saw? Because I mean, how does the title company not know that? So everybody pre-signed? Do you guys see what I'm saying?
They went and recorded a mortgage.
So the buyer just went and recorded a mortgage. They must have had a title company do it for them.
Yeah, they went and recorded a mortgage, sent it over to us like at the final hour. Anytime something happens in the final hour, I go, wait a minute, you know, I hate, you know, everything should be figured out at least 3 days before, not,
Sure.
you know, an hour before signing.
Who's the title company?
Oh,
That's
God.
more
Hang
important than who's the agent.
on. Hang on, I got it.
Just kind of curious, but I mean,
Oh.
and then does your purchase agreement is all written about a contract for deed, right? Or did you just let Sandra handle this?
Sandra's been dealing with a lot of it, but I deal with it when it gets a little bit messy, and now it's messy. So the title company, title specialist, 7777 Washington, Edina.
So Mario probably did that. We'll probably have to call over there and ask what happened. See if they can help. I mean, it's all been done, so I kind of like.
Oh,
to see
nothing's
what-
signed, nothing's done. My guy didn't sign anything. He's not
And
going.
it's past closing now?
We're past close, yeah, because it's supposed to close on Friday was the closing. And that's the day that they sent and said, this has been recorded, this mortgage has been recorded.
So let me just ask this: the house was selling for 200 grand, right?
240, I think we might have
240.
dropped to 230,
Well, okay, so your purchase agreement's written for
200 with 150 cash contract.
I don't understand the
So they were
numbers,
supposed to
so-
bring cash. They were supposed to bring 150 cash. The
and then
clo-
have a contract for the remaining 50.
yeah, for a
The
year.
house
They were
really
doing-
sold for 200,
yeah,
not 230.
yeah.
Okay, so then
And then
did they
they
get a
asked-
mortgage for 150 and come in with 50K more?
Yeah, they wouldn't do it. They then
They're
asked
dropping
us to
to
just take 150. They said, well, we have a mortgage for 150, take that.
I see. So now the mortgage is first in line, and the seller could, you know, they could potentially not pay the seller, and if the mortgage forecloses, the seller's not able to collect their 50K unless they have a note signed on the property, and then. So basically,
Yeah, you can't contract for deed with if you have a mortgage from
Well,
what I,
here's the
you gotta own
problem.
it outright and sell it outright, you know?
they can't, the mortgage company, I don't know what mortgage company is gonna allow the seller to finance the second part anymore. That's. Right, so there's a contract in place, when the mortgage was recorded at 150, that was a bank giving the 150 and the bank borrowed that 150.
Yeah, and all they needed to do is come up with a 200.
Well,
You know what I mean? We said, sure, come with a 200, mortgage it. We don't care, give us 200, but then they said, no, we're just gonna give you 150.
yeah, no, they can't. There's no contract out there that allows them to do that, and there's no bank that'll allow for seller financing.
That,
I don't
if they
understand
were
what bank.
It's such a mess. It's such a mess. That's why I wanted to tell you guys about it. I haven't.
Yeah,
mastered
so
these things.
we're gonna have to dig into this one. We're gonna have to find out who recorded it and what the bank conditions were. So I think title specialist, I would call them and find out who the closer is and ask, you know, how did the bank allow for sellers to finance 25%? I don't understand what bank will allow that anymore ever since all the meltdown happened. So
Long story
yeah,
short, I'm just gonna
we'll
send a
have to look at
cancellation
that.
over and we're probably gonna get gummed up.
Well, I don't know. Yeah, cancellation. Cancel what? They recorded the mortgage. So we need to make a phone call here. I'm pretty sure Sandra did that. Mario did the closing. Well, no, lawyers are $400 an hour. So I first
I
figured to
have a
understand
lawyer.
exactly
He's
what's
got a
going on
lawyer.
here. Okay.
We have a lawyer. We don't want to really involve him anymore because we did a lot of work trying to.
Yeah,
just
no,
get the
I want to
contract.
see your purchase agreement, right? Is it in Sweet Assist?
I'm sure it is. I don't know if that's Sandra's side. I said, I'll deal with the lawyer. I'll deal with this. My seller did not sign anything. So record a mortgage, whatever, deed's not signed. It's not a done deal.
Does Sandra have anything to do with the buyer or just your listing?
I don't just if she's on the seller side, we're on the seller side.
And the buyer has their own agent, right?
Yeah, it's this William Danielson, and then
His own
William
broker.
Danielson with the title specialist in Edina. I'm a Duluth agent, so I had to rely on Sandra for contacts.
Oh, I see. But William Danielson, you just said two things. Either he's an agent or he's at the title company.
William Danielson is the agent. Title company's title specialist.
Okay.
And he's running his own brokerage.
I'll put you on a thread. I don't even know if I have I'll respond to, because I sent some to Francis today, but I'll put you on a thread.
Oh, I'll have to dig through my stuff. I probably got a copy, or I will.
Okay.
Okay, cool. We're gonna look into that. This is a unique case, so
Yeah.
glad you brought it up because I guess I would have seen it here shortly, but that's
I'm
quite
sure
the
we'll
deal.
be chatting.
So everybody realizes, like, the mortgage lenders are going to require buyers to have seasoned funds and show money down to get a house. So this is all backwards. I don't understand.
That's what I said. That was my nice way of saying it. This is a completely backwards deal.
Yeah.
Well, the thing that I don't get is if they were going to bring $150,000 to the table and now want to do a $50,000 or $150,000 mortgage, why can't they just pay the $50,000 cash that they were bringing to the table originally?
Right.
Where's the money?
Right.
Well, my question is, can we bring this back up later on and find out? I'd love to hear what the resolution is on this.
Hopefully it's soon. Hopefully it's by next Tuesday.
Yeah, I think in a couple days we're going to find out what happened here.
I do have a question. So the title for the property, would it be not change? So normally with contract to deed, it changes only after the balloon payment. So now if they are financing conventionally for that 150,000, the bank, whoever finances, has to put the lien on the property. So the contract, the purchase agreement says you wouldn't get the title until the balloon payment. So how did they do the financing with that purchase agreement?
Well, that's exactly what we don't understand.
No
That's
idea.
what I don't understand.
Title at the fifth hour said, oh, by the way, the 150 will be financed.
So
And then the
maybe that
lawyer
150 is not a bank, maybe a hard money lender or something.
That's possible. It
So
still
Lindy
can't
was-
be first position.
Lindy was trying to hope to cancel and retain the earnest money, but then we talked about how the potential buyer that's all flaked out is probably not going to agree to anything like that. So just wonder if there's any recourse and be able to cancel the transaction.
Yeah, as long as there's not a purchase agreement that allows them to do that, then that's kind of like a fraudulently filed mortgage.
I'm just going to forward some contacts to you, Randy.
I'm
going to put you on a thread. You can see the whole thread with the lawyer and everything.
Okay.
Okay.
This doesn't provide
Yes,
value.
we'll have to come back to this because I'm curious how it'll turn out too.
I think
Well, thanks everybody. Sorry I took all your time.
Oh no, that's what this is here for. I'm sure other people have hopefully not have other similar situations, but then they can refer back to this.
Or avoid it because of this. Yes.
Exactly.
Did they show you? Did they have like verification of funds? Did you see 150 grand in like a trust fund or in like a 401?
So that is what I don't know, because I kept saying, we're not going to sign till you get the proof. We're not going to sign this till you have proof of funds. And I think that we did not get it. But like I said, I'm co-list, I just said, put me on so I can help you out. Because Sandra said, I'm just so busy. And so I don't know if we ever got that.
that sounds like something you might miss, but title specialist handle the buyer and the seller side? Yeah, two sides to the transaction.
Nope, we're just one side. We just got the seller.
No, it's
Yeah,
title
and so title,
specialist handling both sides of the transaction for the closing.
Oh, title?
Yeah.
Yes, with the lawyer's help, because the lawyer did a ton of work so that it could be sold contract. You know what I'm saying?
the lawyer for who? The seller's lawyer.
My seller.
But the title company, each side has a title company.
It's
So
all the same.
who?
All
Okay.
that title specialist.
Interesting.
Yep.
Hey, tell me the address quick.
410 Mariners Lane.
Okay.
Got it?
Yeah.
Well, any other questions, or did we want to jump into arbitration?
One thing I would like to ask, I do have a client who's looking for an acreage property somewhere around Kimball, Watkins, Howard Lake, that area. If somebody could has anything, I would like you to help me out.
Perfect. Well, I am down south. I don't have a name, but do we have any other buyer needs or seller needs before we jump into arbitration? So everybody does know that we are supposed to be offering the arbitration addendum for all of our transactions, correct?
Well, we don't need an answer for that. So arbitration is something that the realtor board set up, and basically it has to be part of every transaction. And then I always encourage buyers to sign it. And then you encourage sellers to decline it. And so the reason is because if you're representing a seller, you want to make it hard for a buyer to sue them. A lawsuit costs 400 and something an hour, probably $3, $4, $5 to walk into a courtroom. At that level, if it's 15 grand or more. And so if a seller declines it, the buyer's only option is to hire attorneys and now get into $5 before they can even try to pursue some remedy. So if you're representing the seller, they can go ahead and just file the arbitration, or the buyer can go ahead if they have a problem and file the arbitration for under $1,000. And that's for 15 grand and over. And so it's just way less. And the arbitration board is pretty experienced in real estate where a judge isn't. So courtrooms, you pretty much need a lawyer to help you navigate the process. And then the arbitration, you could have a lawyer, but it's much simpler.
So
So
sellers decline and buyers accept.
Yeah.
Awesome.
Let's see. Now I mentioned, and maybe as we go through here, we'll hit it again. But if you guys heard the $15,000 mark, that's because like in Minnesota, small claims court, if you've ever been experienced that, it's $70. And so if something's under 15,000, they upped it in Minnesota to $15,000. So if there's anything under $15,000, somebody can go to court for only $70 and try to get a judgment against the seller. So that's why that threshold's there.
Did you say $70 or $750 for that?
Well, so arbitration, if you're at $15,000 and more, it costs like $750, $850. We'll have to read through here. But if there's something that's under $15,000, anybody can take anybody to court for $70. That's just the small claims court in any county. There is a note right here on the third paragraph that talks about the $15 or the $15,000. Says, is there a minimum limit for the dollar amount of the demand in arbitration. So it's the next one, not that one, but it kind of summarizes this. Amy can go over that for a second. It's just words.
Yeah, so there is no limit to the amount that the claimant can make in a demand. However, there is a demand for no less than 15,000, meaning if it's less than 15,000, you're going to have to go through small claims court. If it's over 15,000 and arbitration was signed by both parties, then you're able to proceed.
So if somebody goes to small claims court, I would probably recommend talking to an attorney unless they got a pretty clear cut case. Because then the attorney's probably going to get a couple grand if they can make a close-ended agreement just to go in there and say the right stuff and hand over the right document.
So that,
You know, go ahead.
that brings up a good question. So if the fee is at like 10,000, they're going to be ending up paying like $5,000 in attorney's fees. That basically puts them over the 15,000. How would, if they're close to that 15,000, how would you switch it over to arbitration to make it easier?
Well, you can't unless it's 15,000 or more for the claim.
Okay.
And many people will hire an attorney for arbitration too, just to help them navigate everything. Okay,
so then you could put the attorney's costs on there, and then you'd be basically putting yourself into that arbitration situation.
Well, if I don't know if attorney fees are covered in here, I'll have to read a little bit more. If arbitration will award attorney's fees, I don't think so. Let's find out, because I didn't clearly know that. I gotta look at it on my own screen. I can get ahead of you guys a little bit, but I mean, basically it just says if it's under 15 grand, arbitration is not an option. So whether or not attorney fees are in there, I don't know. Let me find out.
I have a question. I thought sometimes arbitration was dealt with the agents first, like in the office between the agents with all their paperwork, saying you did those.
Well, you might go initially, probably try, you're going to take a look at everything and see if you feel like somebody's right or wrong, but it's not officially the arbitration hearing. I think what you might be thinking of is just kind of establishing whether or not somebody's going to win if they try to move forward,
Mm-hmm. Okay.
Let's see.
Okay. And so, if I have a right to claim for 2,500 against the seller who failed to disclose the problem, would this go through as arbitration if I sign the arbitration agreement? Being it is 2,500, it wouldn't. It would have to go through small claims court because, again, it's that $15,000 threshold. Typically there is no right to appeal in an arbitration decision. It'd be basically the same thing as from a district court or a higher court. There are a limited appeal rights for related to certain procedural failures. So if something happened within the procedure, then they can look into that. There's rights against that. So it's not like but once the decision has been made, that's basically their final decision, unless there's been something with the procedures that have been failed. And what is the scope of the disputes that can be resolved through the arbitration program? It is solely related to the disclosure of material facts relating to the property that is subject to the purchase agreement. Material facts could include anything from those in that statute to failure to make other mandatory disclosures under writing. So like wells, septic, methamphetamines, that kind of stuff. What would you have to prove to win in an arbitration? You would have to prove there is fact about the property that is material affecting the ordinary purchasers using or enjoyment of the property, that the seller or licensee knew about this fact, and that the seller or licensee did not disclose the fact. So those are the three things that you would need to be able to prove in order to win in an arbitration case. So we're starting to get down here into the attorneys. That section above there is just explaining that the arbitration disclosure, that's that sheet that they would need to sign when the purchase agreement is executed. And it does say, yes, you can use an attorney if you choose arbitration. Choosing arbitration is simply choosing a dispute resolution process. However, like the court system, an attorney is not required in order to proceed, but you can have
Yeah,
one.
I don't think attorney fees are covered in there.
Yeah, I would think it would say it right there. I know in small claims court, some of the attorney's fees are covered. So it's just that kind of fine line of,
Well, they will not see a hearing under $15,000 in arbitration anyways. So somebody's only option is to go to small claims court and ask if they can get awarded attorney's fees.
and I
Right,
think
you just got to add up the filing fee, the cost of everything, and make a decision on what way to go. I mean, maybe an attorney can trump up something that equals 15,000 anyways. It's kind of arbitrary how to come up with a number.
And then, like we were saying before, who must sign the arbitration to make it valid? Both the buyer and the seller need to sign it to make it valid. So, like he said, buyers should always recommend selling it. Sellers should not recommend not signing it, just to kind of make them go to court.
So you guys know, either court or arbitration, a buyer or seller, there's 24 months to resolve the issue, and after that, there's no more time. So every now and then you get a call like a year and a half later from somebody. I mean, they got to get on the horse and make a decision to get a filing. To that 24 months, it's all over.
Except as fraud is alleged. Interesting. Yeah, so 24 months after the closing. Again, 24 months after the closing.
Oh yeah, I see that. So I guess if somebody can prove fraud, then they can extend it after 24 months.
Yep. So what are the pros and cons? The pros is it's a less formal and not as complex as litigation. It's decided by a arbitrator, so a private citizen. And they're generally less expensive than conciliation court. The discovery of documents is restricted, so it will be less cumbersome. The decision of the arbitrators is final and binding with very limited appeal rights. So the pros of arbitration is that it's going to be your most solid answer once the arbitration does give their answer. And also decisions in arbitrations are made more quickly than in court. So hearings are usually scheduled for 90 days within the receipt of the demand and 30 plus days for the arbitrator's decision. And the party can participate in choosing the arbitrators as well. So that's kind of nice. Arbitration for buyers is pretty nice. The cons of arbitration, you do give up your right to go to court. So anything that happens in the arbitration, you can't, if you don't like the answer in arbitration, you can't go back to court for that same matter. You do give up your right to have a judge or a jury. You do give up your access to the courts and appeals. The discovery of documents is restricted, so it may be harder to access all of your evidence that you might want to discover. I would just talk to the arbitrator about that. They may have ways of getting other documents if they're hard to get. You also give up your rights to the appeal, being you can appeal the arbitrations. Court hearing and appeal process can take many months, if not years, to be final. And even if you win a judgment in court, doesn't mean you're going to get paid right away. And you're also assigned a judge to hear the matter. So it's going to be a judge just assigned to you versus parties can participate in choosing their arbitrators in arbitration. Do the rules cover commission disputes? No, they do not. So if there is a dispute in your commissions, commission disputes between brokerages and their clients must be settled outside of the arbitration process, and may be settled by the Minnesota Realtors if the clients agree. So deciding if arbitration is right for you. The role of the NCDS and their administrators are for scheduling the hearings. They also handle all the communications between the parties and the arbitrators, except the actual hearings. And then the case administrator is available to answer general and procedural questions about the arbitration process. NCDS does not evaluate the validity of the claims. They just basically take in the information and pass it on to your case manager. Who is the arbitrator? The arbitrators are the impartial decision makers whose authority comes from the residential real property arbitration rules, the arbitration law, and the arbitration agreement. The arbitrators are not employees of NCDS. Rather, they will have experience in the field of real estate, law, architecture, building inspection, property management, etc. And after accepting testimony and evidence presented by all the parties, the arbitrators are the ones who make the decisions. The only direct communication with the parties will have with the arbitrator is at the actual hearing. Otherwise, no time the parties can contact the arbitrator directly. All correspondence must go through that NCDS, who will act as the intermediary of the two. The arbitrators will be appointed. Only one will be appointed to the case. However, any party can request a panel of 3 to hear the case. But then an additional fee would be charged. It has their contact information. It has the information that you need to file. So you can mail these. These go to the separate parties. So as long as you have the 4 copies of the demand for arbitration or submission form, the 2 copies of the purchase agreement, the 2 copies of the fully executed arbitration agreement, and the 2 copies of the all inspection reports must be prepared and mailed in to the NCDS. How the respondent, so the respondent is the person that is receiving the claim. They'll receive a copy that NCDS will serve to them, and then the claimant is required to provide up to the date contact information for the respondents. NCDS will not proceed if the respondents cannot be found. So the claim on are able to be found in some sort of way that NCDS can serve them the paperwork. Can the respondent ask if the arbitrator to review a demand to see if it's deficient or unable to be arbitrated? So yes, the NCDS is an administrative agency. It does not evaluate the validity of claims submitted for arbitration. However, the arbitrators themselves can evaluate a demand based on whether it is ultimately or whether it lacks specificity with respect to allegations to the claimant. So even though they can't evaluate the validity of the claims, they can let you know whether it is untimely or if it lacks specificity. So a claim can be changed after it's submitted. It can only be changed in writing up to 14 days prior to the hearing. Within 14 days of the hearing, any new or different information may only be submitted with an agreement of both parties. So you do have to have an agreement to submit anything from both parties. The hearing will be set within 90 days and within 30 days of the parties and within 30 days of the receipt of the parties' calendar of conflicts. Each party will be given the opportunity to provide his availability, and a hearing date will be scheduled on a day that everyone's available within that 90 days. Most of the arbitration hearings are held at the property in question. However, on occasion, the arbitrators may name a different location. The date, time, and location of the hearing will be provided at least 14 days in advance of the hearing, unless the late notice is waived by both parties. And how the arbitration deals with evidence. The parties may offer evidence, both exhibits and witness testimonies that is relevant, similar to court cases. Parties may also be required to produce evidence specifically requested by the arbitrator, if the arbitrator deems that evidence is necessary. An arbitrator is also legally authorized to subpoena witnesses and do so independently or upon the request of a party who wants a witness present. So they are there to help as well, if you need some subpoenas or anything like that. The arbitrator determines the admissibility of the evidence. So basically your arbitrator is the judge in like this transaction. Just they're the arbitrator. They're not bound by law or anything like a judge is. They've been sworn in by the real estate professionals, and they know their stuff, and they're the ones who make the decision, and they're able to do all these extra other stuff. And all witness lists except with expected testimony of each party and exhibits must be provided by the parties to the NCDS no later than that 14 days prior. So anything that you're trying to bring to the table must be added no later than that 14 days prior to the hearing. So the hearing is closed when both parties have had adequate opportunity to present all of their evidence or witnesses that they wanted to submit. Could the rules ever be waived by a party? So yes, if a party proceeds with the arbitration after having knowledge that a rule has not been followed, if the party fails to object to the fact the rule was not followed in writing to the NCDS, then the party has waived the right to object. So it always has to be in writing to the NCDS for any changes or anything that you need to add or argue, I guess. Do you have the right to object? Any party who becomes aware of a violation may file that written request to the NCDS. The arbitrators shall interpret and apply the rules they apply to the arbitrator's powers and duties. Otherwise, NCDS will do so as an administrator of the process. And so when will someone be notified of an award? Not later than 30 days from the date the hearing is closed. So typically those are all sent out within 30 days, and you'd know by then. They're either sent by mail to the party or attorney or by service or filing the award in a legally allowable manner. So you will get notified by one of those. And how the award is determined, the arbitrator is the one who determines the award based on what is just and equitable and within the scope of the purchase agreement. So it's really important what you're putting in that purchase agreement and making sure all of the addendums and everything are with that. The arbitrator may assess the arbitration fees and expenses against any party. Generally, each party must bear its own attorney's fees. That's where it says it. So if you are hiring an attorney, you are responsible for the attorney fees, except that the arbitrator shall be allowed to award a prevailing party attorney's fees if allowed by that statute. So you could possibly get your attorney fees back, but that's only if the arbitrator awards it and you're the prevailing party.
I think
So
they
then-
get the arbitration fee back if they win, right? Well, we'll have to find it. I don't know if you know.
It
But I think
says
that's
the
correct.
arbitrator may assess the arbitration fees and expenses against any party,
Yeah.
generally. Often the winning party is awarded the costs from the losing party as well. So yeah, that'd be probably the fees.
So the
and-
next one is what? Arbitrator awards, somebody doesn't pay, and then we're Minnesota statutes, they can take the award and go set a judgment, try to go after credit, levy bank accounts and stuff like that.
Yeah,
Let's see.
that's it. Oh,
Yeah, that's it on this. If there's any questions, that's great. I think I have a little more information already on that transaction we were talking about before. Does any, Lynn Condos had a question. We don't know. What was that question? It's in
Yep,
go to
I
the
just
chat
pulled
here.
up. So we got Lynn saying if a seller doesn't sign arbitration and an issue arises, can the seller agree to arbitration? So I think back up here, for it to be valid, it needs to be signed at the purchase agreement.
Yeah, I don't know if they can all get together and say, let's just arbitrate. I mean, if it's
I-
within 24 months, I don't see why they couldn't.
I thought if the buyer signed it, they could, and they wanted them to do it, they could do it, but I don't know why they would want to go that route. Unless there's a specific example you were thinking of, Lynn.
Yeah, we probably have to call and ask them specifically.
Yeah, I think that'd be a case by case basis.
So then we have a friend who had an arbitration issue after closing, trying to find out from the details. It was over 5 years ago. So if it's over 24 months, you have to find out that there's fraud for sure. They will not accept, they won't look at it.
My parents sold their house and the new buyers didn't keep grading it. And so the same thing happened. The wall caved in. They tried to sue my parents and they didn't get anything from them.
Yeah, sounds like lack of maintenance,
Yeah, you can't go back. You can't go back in time and fix your own problems. You look for somebody else to do it, I guess.
Yeah. So I'm looking at this claim from this situation that we're talking about. And one, I see a buyer's title company down in La Center. And then I see a seller's title company, probably title specialist, because we have a relationship with them. And Sandra probably had Mario handle the sell side. The buy side is trying to come in with hard money. And I don't know that this was recorded. I don't see anything signed. So I might be confused on if this was actually recorded or if this is their plan. And so what would have to happen to make this deal work? I don't see the problem. Why does the seller care where the money comes from as long as they get their cash? The only issue is the seller can't have this hard money lender be first in line. They need their money to be first in line if we're going to protect the seller. So if I was working for the buyer, I'd say the opposite. But if the seller wants to borrow them this other $50,000, then as long as they're first in line and can foreclose on them within 60 days, they need to write up some type of a note by an attorney and then file that to be first lien. And as long as a CD provider that's helping the buyers get this money will be in second position, there's no reason that this couldn't close.
They tried to roll the offer from 200 to 150 was the big problem, I think.
Yeah.
Yeah, they don't
Well,
want
that's not what I was
200.
just explaining. It was that the seller was going to cover the other 50.
In contract, in a contract for deed with a year.
Yeah. So 150 from the buyers and 50 from the seller with a contract for deed for 12 months. So equals 200, right?
Yeah, and the lawyer says, no way, because then they'd be liable if they can't pay that mortgage.
Right, but not if the seller is in first position. So that's not a mortgage. I mean, it's a let me read the document. Is it a mortgage?
Like a lien.
I lost the damn thing. I don't know if it was a mortgage. I gotta find it.
Are you looking at the email I sent you?
Yeah. Oh yeah, note and mortgage. So yeah, so the lawyer is right. So if it's a note or if it's considered a mortgage, it needs to be recorded in second place. So the sellers need to record their 50 grand agreement first. And then if this one doesn't pay, this contract for deed person's the one that has to try to collect. The sellers are always going to have 50 grand to equity in the property, right? So they can walk with this 150 from this contract for deed person. That all works as long as your attorney gets the seller's note to be first in line.
I understand that. I don't think that lawyer is gonna let him sign.
Well, he
With
just
what
needs to
he says.
understand how it needs to happen. I mean, they then to modify this agreement for sure. This mortgager is given by $50,000. And then here's the note for, I mean, as long as this, wait a minute, who is the seller? Is this
Mine.
HPMN3 LLC a seller?
No, that's a buyer. The buyer's the LLC that was supposed to bring 150,000 cash to the table, but he can't even bring 50,000 cash to the table. We'd be fine if he wanted to bring 50,000 cash to the table and mortgage the other 150, no contract. But the
So
lawyer's
the
not.
seller's willing to give him $150,000 loan already, right?
The buyer. No, the buyer won't sign it unless it's kind of a done deal now. Because I don't really think that we have the trust in that they even have any cash. I mean, if they can't come up with, they said they were going to come up with 150,000 cash, they can't even come up with 50,000 cash in a mortgage to close the deal. You know what I'm saying?
Yeah, but I don't know if I have all the information or if you actually do.
Yeah, the whole thing sounds screwed.
Well, I think I've got the buyer's side getting me a cancellation. We'll see if he asks for that earnest money back on his cancellation.
So Lynn just put in the chat, wouldn't it have to be a personal money mortgage, not a contract for deed? Just like you said, you can't have a mortgage with a contract for deed because the seller would remain on title until
Yeah, it's like the only way if they have no money is the seller borrows them the first 50 and they go somewhere else for the 150 and the 150 is in second place. So the seller walks away today with 150 and then they got, the client owes them 50 as first position. That's how I would do this.
How would that work if you had a contract for deed for 50? They had an additional hard money loan for 150 and they defaulted on your 50. Do you get the property back and they're liable for the 150 or is the original
No, then
seller?
that seller would be liable for that 150 mortgaged against his property. So you're taking the 150, but you're
Yeah.
so then so it does not work out with a
No, that's not right. See, the whoever borrows in the 150 is the one who's going to have to chase down the buyer for it, right? I mean, they're borrowing the 150 from a second party, right? So the seller walks away with 150.
Yeah.
So the seller just becomes a mortgager. They want off the property, and so there would just be two mortgage notes. Right. And so now the seller, all they have left, they've got 150 in their pocket because these people borrowed 150 from another source. That just has to be a second mortgage. So that if the property goes belly up, the second mortgage has to go chase down these buyers because the seller gets the first 50 grand in the property.
So it's not against the property, that'd be against the buyers.
Yeah, I mean, it's a lien on the property, but ultimately it'd be a judgment against the buyer, because when you foreclose on a property, unless that second comes out of the woodwork, they're second in line. It doesn't matter. They can come out of the woodwork, but that's all negotiable. Right, the 50 grand, there will be 50 grand of equity in the property. So the 50 grand will wind up getting paid back to the seller who already walked away with 150.
But they
So the
might
seller
want,
would
but
just
they
get-
might want to up it like 10 grand then to make it 210, get
Yeah.
60,000 in the thing, because that way if they have any fees or anything associated with it, if it does go belly up or something happens, at least they have 10 grand to pay all those fees and they're not coming up with 40, right?
Yeah, that's a great idea. Yep. If they ever have to file legal election, they got a little cushion. But the thing is if the second doesn't get paid and they're at 150, they're probably the ones who are going to have to go ahead and file legal action anyways. Right? So the seller just needs to put their feet up and wait till the house sells and they'll get their 50 because they're first in line.
So the seller would get the 200. If they don't fulfill the deed, then they'd get the property back and they'd owe like 150. So there's still money ahead.
No. The seller's only borrowing the first 50,000. Right? The buyer is borrowing 150 grand from somewhere else. That's second line.
So confusing.
Yeah. Well, the seller's the primary mortgager. So you guys get it? It's just backwards. So it's a tiny loan that the first mortgage is going to be. Most are 80-20, right? 80% for the first and maybe a tack on a 15% mortgage for a second. This is just the opposite way around. So since it's private money, it could work that way. But the private money guy is going to say, no, I want to be first in line. But if they say they'll be second in line, then they're all good. You see, if they stop paying the notes, the seller has the first 50 grand on the title. So the second mortgager at 150 grand, that guy's going to fight all day long to get their money. So they'll wind up doing all the legwork and filing foreclosure. And the seller will walk away with their 50 and the second person will get what they get. Because the property is always going to be worth more than 50 grand.
Well, I've
We
got
can go over it more in
not to
detail.
let it close either. The lawyer says no.
Well, if you guys want it closed, I can talk to him and tell him how I would structure it and he'll agree.
Okay. Let me call him first and tell him you'll be calling.
Yeah, it'd be great.
Well,
if
he
we
can
could
call me if he
recap
wants
next
to.
week. It'd be great if you could recap next week too, what happened.
Will
Yeah.
do.
Yeah, tell him I have a mortgage method to make it work if parties agree. But I guess that's it. Anybody got anything else? We've been an hour and 10 minutes.
Admin fee is still $4.95, right?
Huh?
Admin fee is still $4.95, correct?
Yeah, thanks.
Yeah,
Yep.
I've been chatting with Andrew in the background. He had asked about some like a buyer's packet and whatnot. So I was just guiding him to that, and he had just had that question. But otherwise, I think we got all our questions answered. Otherwise, it'd be
Cool.
great to bring up next week.
Yeah, I'm gonna be running around the city now till 9 p.m. So everybody have a good day.
Everybody have a good day.
Thank you. Thanks for
Thanks,
everything.
Amy. Thanks, everybody. Bye-bye.
Bye-bye. Have a great day.
Thanks, everyone. Have a great day.